Development request. Supplementary list for motion, item number 27.
Please, Your Lordship, I beg to mention an item for listing of withdrawal
Hmm?
for tomorrow, listing for withdrawal for tomorrow, Your Lordship, criminal appeal. Authorized, Your Lordship.
May I please, Your Lordship?
Yes.
My lord, petitioner's wife, Manikjan Begum, was taken by police
Hmm.
on 23/5/25 at about 3 a.m. That means during night. And on the next day, she was allowed to go home. Then again, police came on 25/5/25 and took her. And since then, my lord, the whereabouts of this woman is not known to anybody, including the
Yes.
petitioner who is her husband and son, daughters. There is a 9 months baby with her. So the baby is also with her. Now, since 25/5/25 till today,
Yes.
nothing is known about.
Yes, state. Habeas corpus.
No, I have to take instruction. Here the foreigners tribunals, they were also SP border, election commission, NRC, all of them are party. I'll get the instruction whether what it, two other matters were also listed on that day.
Hmm.
Ultimately, they were found to be declared foreign.
No, they are also declared foreigner. The lady was declared a foreigner by the tribunal. Then thereafter, writ petition was dismissed by the High Court. Thereafter, SLP was also dismissed by the Supreme Court. The question is how to deal with this issue. Thereafter, I think the lady was released because of the Supreme Court Legal Service
Yes.
Authority after spending 2 years in the detention camp. So what is the policy of the state?
Give me
No,
some
no,
time. I have to take
only our prayer is that where she is now. It may kindly be taken at 2 p.m. We are very much anxious because
She was taken as stated by the petitioner, she was taken on March 25.
20
no, May 20,
May.
May 25.
Already, but give me 1 or 2 days time. Today is Wednesday, but if you take up a 10th on Friday, I'll get the instruction.
Our only prayer is where is she?
First is where is she?
Yeah. Thereafter, our
Thereafter, we'll decide the other issue.
Yeah.
And where is the Union of India?
Even of India is-
Heard Mr. M.U. Mahmood. Learned. Counsel for the petitioner. Mr. Mr. R.K. Devchuri, learned. Deputy Solicitor General of India for the response number 1. Election Commission of India. Mr. Nath, you appear for?
Well, I'm appearing for response number 2, 3, and 6 and 7.
Mr. D. Nath, learned. Senior Government Advocate, Assam, for the response number 2, 3, 6 and 7. The petitioner has instituted instant writ petition under Article 26 of the Constitution of India, seeking a writ in the nature of habeas corpus. Come on, the case of the petitioner is that The petitioner's wife. Manik Jan Begum. Was initially picked up from her house on 23/5/2025, along with her 9 months child. And thereafter, both of them were kept in Dhula police station for the night. Though on 24/5/2025, Manikjan Begum was allowed to go home, but again on 25/5/2025, she was picked up by police authorities along with her baby, also with her
Yes.
9 months child. And since then, whereabouts of the two are not known. Post of where it is stated that in a proceeding registered as I am within bracket D, within bracket T, case number is 12 for us, 1013/2021. Oh, sorry, FT, within bracket 4, 812/2025. Before the Foreigners Tribunal, 2015. Before the Foreigners Tribunal, within bracket 4, Dorong at Mongoldoy. The alleged detainee was declared as a foreigner by an order dated 22/02/2018, passed ex parte. When the alleged detainee preferred a writ petition before this court prepared a writ petition, WBC number 6290/2018 before this court. The said writ petition was dismissed by an order dated 14/9/2018. Full stop. Subsequently, a special petition, SLP within bracket civil, diary number 10587/2019. Referred before the Honorable Supreme Court, came to be dismissed by an order dated 1/7/2009. Full stop. It is stated that as the alleged detainee spent a detention period of more than 2 years in the 2 years, she was released on bail as per the direction contained in the order dated 10/5/2019, passed by the Honorable Supreme Court in WBC number 1045/2018, within bracket Supreme Court Legal Services Committee versus the Union of India and others, bracket close. Full stop. Para. As it is contended that the whereabouts of the two persons, that is Manikjan Begum and her 9-month minor child, Moriam Begum, are not known, the state respondents shall obtain instruction as regards their whereabout and place before this court on Friday, release the case on Friday. The counsel for the petitioner shall supply a copy of the writ petition along with an extra each to Mr. Arkadev Choudhury, to Mr. Payeng, to Mr. Nath, to Mr. Payeng. By today? By today?
No.
By today,
Copy.
copy,
Copy has been served already.
extra copy so that they can send it.
But
তার আগতে আরো একদম উপৰত লিখিব Mr. J. Payeng.
for 2 and 3, kindly record. For 2 and 3, Mr. Pine.
Okay, 2 and 3. Okay, Mr. J. Payeng. Learned Standing Council, Home and NRC. 2 and 3, huh? And 5. 5 also? 5. Any election commission? Mr. Okay, H. Kuli, Learned Council. Representing Mr. A.I. Ali. Learned Standing Council ECF for the respondent number 4. Friday, day after tomorrow.
My lord, I have one reservation regarding para 4, my lord. She was,
Para 4 of my order or of the repetition?
no, my petition, para 4, I have some doubt whether in this case or another case, kindly keep this as option open for information, because in another person came who was in detention camp, but she is also picked up.
You clarify?
Yes,
You have made a statement on oath.
I have, whether that case or this case, I am in doubt. So many cases are coming, my lord. That is the problem.
Daily list for admission. Item number 1,
May it please, my lord, we have filed our affidavit in reply. However, it has not come on record. My lord, if it pleases, the case may be fixed for hearing.
The reply had.
Monday?
Reply. Not
Monday?
16.
My lord, can it be 7 and 16? It won't be possible actually.
17, we will be sitting in a different division bench. I have been told. Entire day will go. Take the risk.
My lord, a subsequent date after 16th, any day, my lord.
But you know, she fixes us also appearing. 23rd. Mr. Dina, Miss
P. Devi, my lord.
P. Devi Learned Council for the petition. And Miss Dina. কে পড়া হল কে কলিটা আগত লিখি দিব রিপিট করে দিব petitioner Learned Council for the petitioner has submitted that an affidavit in reply has already been filed, but the same is not taken to case as sought for by the Learned Council for the parties raised by case on petition.
item number 2,
This appeal from jail is preferred against the judgment in order dated 12/3/2025, passed by the Court of Learned Additional Session Judge, Dibrugarh, in Sessions Case Number 109/2022. Full stop. In the trial, two accused persons face the charge of under section 302 IPC read with section 34 IPC. Full stop. The accused appellant here is one of the accused, another two accused persons who have been convicted by the said judgment and order. Full stop. The accused appellant has been sentenced to undergo rigorous imprisonment for life and to pay a fine of ₹5,000, in default of payment of fine, to undergo rigorous imprisonment for another 6 months. Full stop. The criminal appeal is admitted. The case records of Sessions Case Number 109/2022 be called for, issue notice returnable in 4 weeks as Ms. A. Begum, an additional public prosecutor, has appeared and accepted notice on behalf of the responding state. Issuance of formal notice to the respondent state is dispensed with. Post of you have naam diyo. ठीक है ये लिस्ट कौन सा yes I got हाँ हाँ amicus or valid है right amicus আছে एक मिनट देखो हेलो नहीं amicus नहीं है to present the accused appellant in this appeal, Mr. Minmoy Dr. Learned counsel from the panel of amicus curiae is appointed. Full stop. Mr. Dr. is to be informed accordingly. Lays the case after 4 weeks.
Item number 3.
I go to next time. I go to next time. ওই to POXO আছে। This criminal appeal from jail is referred against the judgment dated 3/10/2024 and an order on sentence dated 7/10/2024 passed by the Court of Learned Additional Session Judge come Special Judge POXO Kamrup Metro Guwahati within bracket Special Court. In sessions within bracket Special Case number 46 of 2023 arising out of Khatri Police Station case number 32 of 2023 by the judgment and order on sentence, the accused appellant has been convicted for the offences under section 6, POXO Act, as well as and under section 376 AB, IPC. Postal. He has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 20,000. In default of payment of fine, to undergo rigorous imprisonment for another 1 year under section 6 POXO Act, taking into account section 42, POXO Act. Postal. The criminal appeal is admitted for hearing. The case records of so-and-so case number be called for. Issue notice returnable provisions as Ms. Begum.
Lordship,
Panel.
I'm a legal aid
Oh,
counsel. My
Ms.
name is
Sharma.
not from here.
B. Sharma, lad, legal aid counsel for the appellant, accused appellant, and Ms. A. Begum. By indicating the accused appellant is to take steps for service this upon the respondent number 2, informant in terms of the practice direction, notification number so. The additional public prosecutor is to obtain report as regards service of notice upon the respondent number 2, that's informant from the officer in charge, Khatri Police Station, by the next date of district.
Of that.
The name of Ms. B. Sharma, learned legal and counsel, is to be reflected in the call list.
Item number 4.
What is this?
15 years.
294? Cost title?
Oh, my lord.
506?
I'll correct it, man.
Huh?
I'll correct it, man.
No need to correct this statement.
Now,
Criminal intimidation and obscene words
yes, sir.
under CRPC.
I'll correct it, man. I'll correct it.
This criminal appeal
Page 2.
under section 415. BNSS 2023
That's good.
is directed against a judgment an order dated 2/7/2024 passed by the learned session judge Sankotem Nagar at Hojai in special within bracket NDPS case number 114 within bracket H of 2022. By the judgment and order dated so, the accused appellant. How many?
2, man.
Accused appellants have been convicted under section 20 within bracket small b, within bracket small Roman 2, within bracket capital C, Narcotic Drugs and Psychotropic Substances Act 1985. And they have been sentenced to undergo rigorous imprisonment for 15 years and to pay a fine of rupees 1 lakh each. In default of payment of fine, to undergo simple imprisonment for another 6 months. We have gone through the contents of the memorandum of appeal. The criminal appeal is admitted for a hearing. The case records of so should be called for. Issue notice returnable in 4 weeks as Ms. Begum, A. Begum, NZ Dr. the counsel for accused appellants and A. Begum, additional public proceedings as Ms. A. Begum, they appear accepted. Extra copy of memo of appeal is the case after 4 weeks.
I may be allowed to correct. I
No,
will.
now it is not the procedure here. You have to correct it.
Madam.
Item 5.
No, please, your lordship. Lordship, this appeal is directed against an order of the special court on the point of sentence.
Hmm.
Now, what has happened here, lordship, after the charges were framed?
You've been consistently aggrieved by inadequacy of sentence.
Lordship, lordship will kindly appreciate charged under section 38 of the UAP Act. Lesser punishment is under 120B. Under 38, it may extend to 10 years with fine. Now, if your lordship will see, here in this case, charges have been framed on the very next day. They plead guilty. In the meantime, they are UTPs for 1 year, 2 months, and all. And that is taken as RI for the period already undergone. Now, another aspect of the matter is, he has not yet been sentenced. So from where RI will come? He is sentenced only now by the impugned order. So there is no RI as on date.
What is the punishment? 38
Lordship will come to page 19.
page.
Page 19, that is a part of the impugned judgment.
38 UAPA to something.
Page,
You want to say that they are in
they are
custody,
they are UTPs on the day.
UTPs.
Now,
But 38 is simply is imprisonment. 38 is punishable
Yes, yes.
simply with imprisonment.
which
So imprisonment may be rigorous or may be simple.
now, Lordship, as on date, on the date when he was sentenced, he is a UTP.
Yes.
There is no question of, because it says RI. That I am just pointing it out, though I have not taken a specific
It
stand.
could be read off with section 428.
That is what, no. So far as Lordship, the
Now,
punishment
428,
is concerned. Punishment of the 38 is concerned, Lordship. Lordship will see, these are members of some prescribed organizations. Whether the period undergone as UTP will suffice, that is what your Lordship has to consider.
This has to be read in conjunction with 428 here.
Yes.
See. Just to add one more line.
Hmm.
428, where an accused person has on conviction been sentenced to imprisonment for a term, not being imprisonment. So the period of detention, if any, undergone by him during the investigation, inquiry, or trial of the same, and before the date of so and so shall be set off. So one more line is to be added. The period undergone and invoking provision of 428 CRPC the period undergone in the during the trial is to be counted as a sentence and it is settled.
That-
Could be one possible way
that-
of
that could
interpretation.
be, but on the larger aspect of the matter, Lordship has to consider whether this would be adequate under
That
section
we'll see.
38. So that your Lordship has to consider.
But so far, 38 is imprisonment.
Yes, Lordship.
It gives rigorous imprisonment. Page 19, there is a sentence imposed,
Yes,
rigorous. So as an UTP, it does not undergo rigorous. This is your submission.
the Lordship, I make it very clear, I have not taken this stand in my appeal, but it appears there is something to it. Because,
And I for that the inadequacy is another thing.
yes,
But sentence period undergone as an UTP, and this is a matter which is
that
can be molded.
that can be, Lordship, that can be.
That can be molded. Inadequacy is only issue.
That's
But
whether,
that the UTP period undergone this thing, that thing, it is a matter of one more line.
that is why I have pointed out to your Lordship, I have not specifically stated this in my appeal. But however, Lordship,
Heard Mr. Arkidev Chudri. Learn it. Deputy Solicitor General of India. For the appellant. Also, the instant appeal under section 21, within bracket 1 of the National Investigation Agency Act 2008, read with section 337, Code of Criminal Procedure 1973 is preferred, challenging the final orders passed by the learned Special Court, NIA, Assam and Guwahati. In Special NIA case number 02/2022 on the point of sentence, custom. The two respondents hearing were accused persons who faced the trial, who were charged in Special NIA case number 02/2022. Charges were framed against the two respondents as A4 and A5 in the by the Learned Special Court. Under section 120B, IPC, and section 38, Unlawful Activities Prevention Act. Full stop. When the charges
Lordship will see paragraph 7 and 8 of the appeal, Lordship.
they filed application or what?
Yes, they filed application, Lordship.
Where it is mentioned in the order?
In the impugn order, it is not there. But I have filed the petition, Lordship will find at page 22,
Page 22.
page 22. That is in respect of A4
Okay.
and page
Uh,
25.
the Federal Special Court, about the respondents. pleaded guilty by filing petitions, pleaded guilty to the charges. And the special court, after hearing the parties, has ordered that has considered it appropriate to convict them and to pass sentences equal to the period they had undergone as UTBs. Full stop. The respondent number 1 had spent about 1 year, 2 months and 24 days. And the respondent number 2 had spent about 1 year, 3 months and 1 day in incarceration. Full stop. Para. Being aggrieved by and despite the sentences so passed. On the ground of inadequacy, the instant appeal is preferred. Issue notice returnable. In 4 weeks, the appellant shall take stage for service of notice upon the respondents by registered post with JD
So
within 3 working days promptly.
in fact,
Had it been revision, we would have heard you on merits, but since it is a statutory appeal,
Lordship,
you are a bit prevailing.
Item 6,
Heard Mr. T.J. Mohantola, Senior Counsel, assisted by Ms. B. Sharma, Learned Counsel for the appellants, and Ms. A. Begum, A. Begum, Learned Additional Public Prosecutor for the respondent number 1, State of Assam, post of this criminal appeal under section 415 within bracket 2, Bharatiya Nagorik Surakha Samhita 2023 is directed against a judgment. An order dated 7/4/2025 passed by the learned Special Judge POXO at Kulaghat in Special POXO case number 302/2020, arising out of Dergaon Police Station case number 106 of 2020. Full stop. We have gone through, by the judgment and order dated so and so, the 2 accused appellants have been convicted for the offences under section 376 within bracket 3, IPC and section 6, POXO Act.
No, my lord, there are 2 appellants. One is, my lord, your lordship,
Oh,
can be page,
The appellant number,
page 75 will be clear, page 75.
the appellant number 1
Appellant number
has
1,
been found guilty of the offences punishable under section 8 and section 12 POXO Act. And the appellant number 2
understood.
has been found guilty for the
Understood, thank
offence
you.
under section 376,
Ultimately
3
6
IPC and section 6,
of the process.
POXO Act. Full stop. In view of section 42 of the POXO Act, the appellant, the accused appellant number 2 is sentenced under section 6
My lord.
POXO Act. Full stop. Para. The accused appellant number 1 has been sentenced to undergo rigorous imprisonment for a period of 5 years and to pay a fine of rupees 50,000 under section 8 POXO Act and to undergo rigorous imprisonment for a period of 3 years and to pay a fine of rupees দুইটাৰ লিখিব হা 20,000 দুইটাৰ লিখিব with default stipulation under section 12 POCSO Act. On the other hand, the accused appellant number 2 has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 1 lakh
1 lakhs.
with default stipulation. First of all, the special court has ordered that the sentences are to run concurrently. First of all, well, we have gone through the contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The case records of so-and-so case number be called for issue notice returnable in 4 weeks. As Ms. Begum has appeared and accepted notice on behalf of the respondent number 1 from a state of Assam, issuance of formal notice dispensed with extra copy within 2 working days. Accused appellant shall take steps for service of notice upon the respondent number 2 does informant in terms of the practice directions notified so-and-so. The additional public prosecutor is to obtain a report as a service of notice upon the respondent number 2 does informant from the officer in charge Dargah police station by the next date of listing. This is the case after 4 weeks. Notice in the
Yes,
IA.
yes, I notice maybe issued, my lord, and record also already called for in the main appeal.
Mr. T.J. Montal and counsel for the applicants appellants and Ms. A. Begum, the additional public prosecutor for the opposite party, just respond number 1 from a state of Assam. The instant application under section 430 within bracket 2 PNSS is preferred by the applicant's appellant seeking suspension of execution of the sentence is passed against them and for their release on bail. First of the applicants as the appellants has preferred the accompanying criminal appeal number so-and-so against the judgment that is so-and-so issue notice in 4 weeks. Steps same.
Step same, my lord, as
Step same. The objection on behalf of the state to the instant application is to be filed on or before the returnable date.
my lord. But your lordship, can you fix a returnable date now? Returnable date will fix.
4 weeks.
My lord.
4 orders. Item 7.
So the victim was directed to issue the last occasion now.
This report is there.
Served.
1-5.
So Dotto is for appellant,
Well,
Bhuiya is for state. Loazima court order says service. No, not Loazima, office note. Respect of flag SR. SR court say flag fund. That is in the pillar. So yet is SR. SR to court say flag on record as. Alright, Mr. M. Dottal and amicus curiae for the appellant and Ms. B. Bhuiyan and senior counsel and additional public prosecutor. Listed by Ms. M. Das. M. Das or R. Das? R. Das. Counsel for the respondent number 1 from state of Assam. From the officer in charge. Nagaon. From the case papers. It is noticed that notice upon the respondent number 2 that's informant has been duly served. Also a report of the officer in charge, Nagaon police station, is with the case paper, case record. Also. The paperwork is already ready. Also. To represent as none has appeared for the respondent number 2, despite service of notice, we deem it proper, in the interest of justice, to appoint M. Mormon learned counsel from the panel of legal aid counsel to represent the respondent number 2 in this appeal. Post of the office to furnish. You have received case paper books?
Yes, ma'am. Yes.
Was there, but because of provided first phase. It was there earlier. Your Worship.
Okay. And office to furnish the paper books. Paper, a copy of the paper to Miss Barman, learned legal aid counsel for the respondent number 2, as well as to the learned additional public prosecutor. Within 7 days from today, office to list the case for hearing in due course.
I will.
Then number 8.
Going.
May I please lodging? Lordship, appeal is already admitted and LCR received lordship. And respondent number 2.
Oh, has appeared. So paper book,
Lordship,
what Miss Deep or Pujari learned counsel for the,
I'm a legal aid
oh,
counsel.
learned legal aid counsel for the accused appellant. Mr. R. Kosik, learned additional public prosecutor for the respondent number 1, State of Assam, and Miss S. Medhi, learned legal aid counsel for the respondent number 2, that's informant poster. As the records from the trial court. Yes, records from the trial court have been received. Office to prepare the paperwork poster. There is the case after 4 weeks for a report as regards readiness of the paper.
Item number 9.
Yes.
Well, we are before your lordship for the bail of the appellant, my lord. 15 months is behind the bar, though she was convicted for life, my lord. But I take your lordship, if your lordship, they have filed an objection also. That, evidence of the whole evidence, if your lordship analysis, my lord, your lordship will find that there is no scope how the conviction. The allegation is that mother has attempted to kill 2 child and 1 child died, and 1 child of course recovered is from the hospital. My contention was that I went to the bus stand, there was an accident, my lord. But the one witness has said that no, I have assaulted the child. As a result, the child died. My lord, no mother will do that much, my lord.
I guess it's there, Lordship. So paperwork may be prepared, Lordship, and will be here on like.
The paperwork definitely will be prepared.
This is a there.
May I be permitted to read the evidence, my lord?
Yes.
I take your PW one.
First, the postmortem examination report.
Postmortem. Thank you. My lord,
Head injury.
PW 5 minutes.
Demortem.
Dr. Manoj Kumar King.
Blunt impact. I have seen.
Opinion is that, in my opinion, death was due to the coma as a result of the head injury. Injured was antemortem and caused by blunt impacts approximately since time of since 12-24 hours.
Yes, sir.
But other evidence should I read?
Hmm?
There are other evidence also.
We have read from first to last. Make your submission.
But,
PW2 and PW4.
Yes,
Then both doctors.
yes. The doctor has not
End of the
given-
matter at the 389 stage at least.
But there
End
was,
of the matter at 389. And the injury, it is not by falling. Cannot be by falling on hard surface.
but doctor has not categorically has said anything in my opinion.
Eyewitness,
Eyewitness, they are also not very clear, madam. I
not
take.
clear, I have noticed, sir.
Madam, the others notice from where?
Okay, you
From
make
how-
submission.
Madam, the PW1, he said that I came to know about the incident around 9:30 p.m. and went to Barbara Medical College and learned about the death of my son and injuries. There is a father. He has not seen. I did not see the incident. Then PW2, Hafiza Praveen, on that day I was not examined by police. Later I was examined by police. I forgot when I was examined by police. I saw a gathering about 40 people at the place of occurrence at Mokipur Maina. Nancy and others were present at the place of occurrence. I do not know about the location of the house of the informant, Abdul Latif. I do not know the father's name of the informant. I also visited the Barbara Medical after the incident. Reaching the Barbara, I saw the child of the accused, Hanifa Nasrin, was being treated medically. My husband, Trafiq Ali, Ahmed, and my mother-in-law and the relative visited the Barbara. It is not a fact that I have deposed the false story of the tutor informant to the Abdul Latif. Then when PW3, at the time incident, I was inside my house. Police did not examine me in this case. Then PW4, the distance from my hotel and the residence is about 1 kilometer. And since the after incident, before coming to the place of incident, I was daily working in the hotel. After PW2, I have read, madam. PW2 said that informant Abdul Latif is my related brother. About 1.5 years back, one day about 8 p.m., hearing the hue and cry in front of my house, I came out from my house and saw the accused Hanufa hitting one of the children against the hard substance of the road. And the people already arrived at this place, tried to resist her. I also saw one of the children of the accused Hanufa Nasrin lying on the road. That children had already died. Another child had already been killed by Hanufa Nasrin by same way. The attending people immediately took the injured child of the accused. On that day, I was not examined by police. I saw gathering about 40 people. And when I do not know about the location of the house of the informant, I do not know the father's name of such. I also visited the Borpara. Well, I specifically not said anything. Specifically, there is no, in the chief, she said that she saw that there was an injury and he given a stroke of the head of this child. But my lord, in the cross here, it has not been established, madam. And my lord, earlier, there was, it is admitted fact that there was a case against earlier also. The question is that no mother will child one after another child. First child was accidental death. And in that case, her conviction was.
How he sustained injury, the baby?
But we have suggested that there was a hit and run
Suggestion
by
does not
vehicle.
displace.
Hit and run by a vehicle. Though it is not admitted, suggestion was not said denied. But
Suggestion remains in the realm of suggestions only.
but I have given.
And either by preponderance of probability. That cannot be caused by falling on hard substance. It has to be traced.
But there is no specific
Hard,
cogent evidence
Mr.
on this point.
S.C. Viswas. We hearing you in appeal at full strength, at full steam. How the two child can sustain injuries? One is simple, definitely.
He's all right. He's
But-
going happily.
Sustain injuries.
Second, another child.
You are the person
My lord, I being a
who
mother.
was with
But
both the child. What is your explanation? Though not required.
I have not done it. That is my explanation.
Oh, that is all, that's.
My lord, no
That's
mother
okay, that's
would
okay.
go to that extent.
That's okay.
To kill its
Clear
own child.
denial.
To kill own child.
Clear denial.
Yes.
All this nowadays happens.
But every mystery remains something which I could
History
not deny.
remains. All this patricide, filicide, everything happens. Everything is possible nowadays. Everything is
My
possible.
lord, I have dealt that case.
Nothing is impossible.
I was in the earlier case
Or
also.
Mr.
I
S.C.
tried to
Viswas, learned
know from her
counsel
too.
for the applicant,
Why-
excellent, and
why
Ms.
is the
A.
whole
Begum,
case
learned
has come
additional
up?
public prosecutor for the opposite party, comma, number one, opposite party, comma, state of Assam, postal. The applicant has preferred the instant application under section 389, comma, Code of Criminal Procedure seeking suspension of execution of the sentence passed against her and for her release on bail. Full stop. The applicant as the appellant has preferred the accompanying criminal appeal, comma, criminal appeal number 196 of 2024 against a judgment and order dated 27/2/2024 passed by the learned session judge Borpeta in sessions case number 129 of 2021. Full stop. By the judgment and order dated 27/2/2024, comma, the accused appellant applicant appellant has been convicted for the offenses under section 302, comma, Indian Penal Code for committing the offense of filicide and also under section 323 IPC. Full stop. For the offense under section 302 IPC, the applicant appellant has been sentenced to undergo life imprisonment. Only life imprisonment?
Yes. With fine also.
Is it fine is not there?
Fine is there. Fine for police.
No, simple, because of filicide perhaps. For the offense under section 323, IPC, the applicant appellant has been sentenced to undergo simple imprisonment for 1 year. Full stop. No order for payment of fine has however been made. It has been ordered that the sentences would run concurrently. Full stop. Para. The case records of sessions, case number 129 of 2021 are received. Full stop. For the purpose of consideration, of the prayer made by the applicant in this application, comma, we have gone through the testimony of the prosecution witnesses, including the medical evidence in the form of post-mortem examination report and injury report, as well as the testimony of the autopsy doctor, PW.
PW5.
PW5, who performed the
Postmortem.
post-mortem examination on the DG's child, and the medical officer, PW 8, who provided the treatment immediately after the incident to the other child of the applicant, PW9, applicant, full stop. It is found that the prosecution witnesses, comma, PW2 and PW4 had testified as eyewitnesses. Full stop. According to their accounts, comma, the applicant addressed one of her child, which resulted into the injuries, comma, as recorded in the, which is found to be consistent with the injuries recorded in the post-mortem examination report. Full stop. Para. In considering the prayer for execution or suspension of the execution of sentence and the prayer for bail, comma, involving a serious offense like murder, punishable under section 302 IPC. More particularly when the offense is filicide, comma, the court should consider all the relevant factors like the nature of the accusation made against the accused, the manner in which the crime is alleged to have been committed, the gravity of the offense, the desirability of releasing the accused on bail after he or she has been convicted for committing the serious offense of murder. Stop. While undertaking the exercise to ascertain whether the convict has fair chances of acquittal, comma, what is to be looked into is something palpable. In other words, comma, something which is very apparent or gross on the face of the record, comma, on the basis of which, comma, the court can arrive at a prima facie satisfaction that the conviction may not be sustainable. Full stop. Having considered the materials on record, comma, we are of the prima facie view that the appellant has not been able to make out a prima facie case for suspension of execution of the sentence passed against her and for her release on bail. Full stop. Consequently, comma, the instant application preferred under section 389 CIPC stands rejected. However, these observations tentative shall not be
Yes.
only for the purpose of consideration of 380
Regarding paper book, madam.
appeal. Heard Mr. S.C. Viswas, learned counsel for the appellant, and Ms. A. Begum, learned additional public prosecutor for the respondent state. Full stop. As the case records of sessions case number 129 of 2021 are received, comma, the registry to prepare the paper book. Full stop. Of service. Who is appearing for respondent number 2?
Though we have made part of it, is not required, madam.
Huh?
Though we have made part of it, it is not required.
No, so it was, initially you made party. Then, steps were taken.
Yes,
Wakalatnama has also been filed.
yes, that they are not repairing.
That is your husband perhaps.
Yes,
None has appeared for the respondent number 2. Though the name of the learned counsel, today on call, though the name of the learned counsel for respondent number 2 is reflected in the call list. Post stop. Place the case after 4 weeks for a report as regards the release of the paper.
Item number 10,
Maybe the lordship, this appeal is already admitted. Maybe the lordship. Lordship, this appeal is already
Yes.
admitted, but the office note dated
Appeal
5/5/2025
admitted, records called
says that
for, ECR have not been received.
in another case,
ECR.
74 of 20.
Heard Mr. N.J. Gogoi. Learned counsel for the accused appellant. And Mr. R.R. Kosik, learned additional public prosecutor for the respondent states. Full stop. Peruse the office note dated 5/5/2025. Full stop. Please this list appeal along with criminal appeal number 74 of 2024 after.
item number 11,
Heard Mr. N.B. Chaudhary,
It's fine.
learned counsel for the applicant appellant, and Mr. R.R. Kosik, learned additional public prosecutor for the opposite party, number 1, no, number 1, state of Assam.
Services.
Full stop. As per,
4 days delay, ma'am.
as per office note dated 3/12/2021. Service upon the respondent number 2, service of notice upon the respondent number 2 has been affected by the officer in charge, which police station?
Morigaon Police Station.
Morigaon Police Station, full stop. The instant application under section 5 of the Limitation Act 1963 is preferred, seeking condonation or delay of 5 days in preferring the connected accompanying criminal appeal against a judgment. An order dated 22/7/2024 passed by the learned additional session judge special judge within bracket POXO Morigaon in POXO case number 07 of 2021. Post of by the judgment and order dated 22/7/2024, the applicant appellant has been convicted for the offense under section 6, Prevention of Protection of Children from Sexual Offences Act 2012. And he has been sentenced
20 years.
to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 10,000, in default of payment of fines, to undergo for rigorous imprisonment for another 3 months. Full stop. We have gone through the statements and amendments made in the instant application. More particularly, paragraph 7 thereof. Full stop. Having gone through the statements and amendments in the application, we are of the considered view that the applicant appellant has been able to explain the period of delay of 4 days, showing sufficient cause. Full stop. In any matter of any view of the matter, as the applicant appellant has been sentenced to undergo rigorous imprisonment for 20 years, the appeal preferred, the accompanying appeal, criminal appeal preferred by the applicant appellant is to be heard on merits to subserve the interest of justice, notwithstanding the technical consideration of delay. So Mr. Kosik, learned traditional public prosecutor has fairly submitted that since the applicant appellant has been sentenced to undergo rigorous imprisonment for 20 years, the accompanying criminal appeal can be heard on merits is to be heard, may better be heard on merits by considering the period of delay of 4 days, which is hardly considering the period of delay, which is hardly 4 days. In view of the above, the instant application stands allowed office to register the accompanying criminal appeal and thereafter to list the same for admission.
Items 15 to 17.
May it please your lordship. Well, item number 15 to 17, my lord, arise out of the same case, my lord. Wherein, my lord, if your lordship will kindly see, the 3 accused persons, the 3 appellants, my lord, 2 of them, my lord, were sentenced to life imprisonment. And the appellant in item number 15 was sentenced to 7 years, my lord. He was convicted under 120B only, my lord. So, my lord, let the item number 16 and 17 be taken up first, my lord, then the item number 15.
That Chelawala, my lord.
Oh,
I have given a brief note, my lord, last time, just list of the dates, my lord.
let me find out the brief.
So nothing to do. If it is not there, we are having my phone.
Let me find out. Yes, yes.
Okay, it is there now.
In the brief, where is the judgment?
Yes. On the compilation is there, my lord.
In judgment is at
In the
page
compilation, page 78 to 119.
78.
78. The remaining paragraph your lordship will find
Well, you are for which one?
for 16 and 17.
Name.
Namely Abdul Majid and Zakir.
Mojid.
Majid and Zakir.
Mojid and
But if your lordship kindly see the FIR first, my lord, that will
we'll
make.
see.
Huh?
Mojid. Page 78. Mojid.
Yes,
And
Zakir. Majid is item 16. Zakir
no,
is the.
page 78, the copy of the judgment.
Oh, yeah, yes, no.
Where is that Zakir? Zakir to portfolio. No,
Page,
I don't.
my lord, your lordship will find 100, paragraph 36, basically from the.
No, in the accused detail. His name is missing.
Zakir.
A2 is the.
A2, A1 is Majid, A2 is Zakir.
No, right. Where is A2?
A2,
Details of A2? It's missing.
Hmm.
Page 78 and 79.
yes, yes, yes.
That is what I am trying to find out.
78, yes. Your lordship will find A1, A2,
Where is A2?
79, page 30. Oh. Page 79,
That is A3.
A2 also.
Oh. Okay.
A2.
A2. So you are representing A1 and
one,
A2.
1 and 2.
Under 120B, imprisonment for 302. And IPC some 392. Maybe sequence of. Asmat Ali. That also we have. Sunrise, sunset, 14 years. Seven years. So 7 years under 120B. Life
what-
under 302.
Yes,
10 years under 392.
392,
Both same.
both same.
Okay.
Only so far fee is concerned, is 7
Okay.
years. That I have given my note also, it is there. Madam.
Ah.
Now, kindly see the FIR, madam, first. Main accused, who is the main one? Page 1. For the compilation.
Yes.
Accused, your lordship will find 1, 2, and 3. Hussain Ali, your lordship has seen. Hussain. Now, kindly see page 2, my lord.
Third one is Hussain.
Hussain here in the FIR.
Huh? Okay. In a fire.
Yes.
So he turns out to be Asmat or what?
No, my lord. He has absconded. Asmat has got under 319.
Okay. Asmat under 390.
319. Initially, if I submitted, Asmat is not there, man. His name is not. there.
Okay.
Now, kindly see my FIR, man.
Hmm.
I have the honor to state that around 7 p.m. on 9/12/14, accused number 3 means Hassan. Your lordship compilation I have given two
No, I
compilation.
have one, but my esteemed sister has.
Yes, we have given last time too. Yes, last time we have given. No, come up with you. Why am I? So, immediately we give.
You think what Hassan is up to? Yeah, what my table first? 828.
So, accused number on 7, on a 9,
So
12,
this is Ram Bhavan Jadhav.
Right.
And informant is his wife.
yes,
Okay.
Tanuja Brahma,
Hmm.
PW1. Now, kindly see, my lord. She is saying that on 9/12/14, accused number 3, Hassan Ali, told my husband, late so and so, that there was a scrap material shop at Bijni and that the shop should be seen visited. Accordingly, my husband, along with accused number 3, went towards Bijni in an Indica car bearing a so and so with a cash of rupees 2 lakhs. But my husband did not return till the next day. I dialed up his number, but it was found switched off. I searched for him at various places, but could not trace him out. Around 9:30 a.m. today, that is 11/12/14, I have come to learn that the accused persons, in furtherance of the conspiracy, had killed my husband in the house of accused number 1, situated at village Katikatia within the jurisdiction of Bijni police station, snatched amount of rupees 2 lakhs, which my husband carried with him and kept in the car somewhere. And that when accused number 1 and 2, that is Majid and Zakir, were carrying up the dead body of my husband on a tela to hide it somewhere, the local people caught them red-handed. So Majid was not there in the tela. Hassan has taken him. Where Hassan has gone, nothing is there. Subsequently, he is absconded till today.
Yes.
Now, in this case, what happened, my lord? Nobody has seen, my lord, the commission of the murder, or it has not been proved at all. Dead bodies were found in a tela. which was seen by PW 4 and 5, as per their kind of the, sorry, 3 and 4.
So that was by strangulation.
Yes. 2 and 3.
To 24 hours. 12 to 24, 11.
Now, surprisingly, Hassan has gone by where he is.
Hmm?
He is the main person. Without Hassan by the inquiry also, how it could be completed matter. Actually, he is the person he has taken him.
When this indica was recovered,
Yes, Indica recovered, and your lordship will find owner of the Indica also, he was also PW authorization. Caesar witness, my lord.
11, 12
Obviously.
by Mojid Ali. Mojid Ali identified.
Mojid Ali.
Hmm?
Allegation is that matter in the house of Mojid Ali, might have this murder took place.
Hmm.
That is the allegation.
That is, he is A1.
A1.
And as
And-
per Caesar list,
Yes.
page 8, identified by Mojid Ali, it says.
Yes. Is Caesar, yeah,
Presence undersigned, Damodar. Tata Indica.
PW5 is the owner of the vehicle.
Hmm?
Owner of the vehicle, PW5.
PW5.
5.
Okay, let us see PW5 then first.
Page photo. Page your lordship will find the lineup. Yes,
I'm
page
owning a dhaba in
36, man. 36.
Randa dhaba jointly by Milan Duty.
Oh,
Occurrence
oh, my
took place
owner of the dhaba where Indica was seized.
on the date of
Oh,
occurrence,
okay,
vehicle
was
was found in front of our dhaba. For consider when we went near the
It's a
vehicle,
case in
on the scene blocked. Waiting for many, when we see nobody to
seven.
clean the vehicle. We informed the matter to the Howley police station. Vehicle was colored in registration number is so and so. Thereafter, police came to the vehicle to the Howley police station. The following day, came the spot. Is Dipang for about okay. That was on 11. 11. So he informed the police.
PW7 is the owner of the vehicle.
7 is the owner.
Owner of the vehicle. 5 is the owner of the dhaba. In front of his car.
I know reduced.
PW7 page 40.
Sapaguri.
40.
The FIR was lodged to which place?
Page 1.
Bizni
Yes.
police station. Very good term. No, he is not the owner.
Page 7, my lord.
Page 39.
Page 40. Page 40.
Oh,
PW7.
Sanjay Das.
Sanjay Das.
Driving license.
Occurrence owned. Just gave by me the premises of the deceased. No, doubt. The driving is following a husband of that beat. He is from Bongaina police station area. Bongaigaon Police Station area. Bongaigaon. PW5. Bongaigaon. Victim is a resident under which police station?
Who is,
Bongaigaon.
who are?
Bongaigaon
Yes, Bangor district.
Police
Bangor.
Station. Bongaigaon Police Station.
Yes,
Then vehicle was recovered within areas of Howley Police Station.
you know,
Perhaps PW5 says he is a resident of Howley Police Station.
yes.
BH College,
He
Howley.
is from district Borpeta.
Howley.
Howley.
So
Third
vehicle was found at Howley,
At Howley in the district of Borpeta.
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 And
Right side, madam. Howley, right? side.
Bongaigaon.
Yeah. Bongaigaon.
Bongaigaon, Borpeta. And what the lady says?
Lady says, my lord, PW1.
In FIR.
Oh, FIR is paid 2.
Shop at Bizni. Bizni.
Yes. Business in the Bongaigaon district.
Bizni in Bongaigaon district. Bizni, Bongaigaon. Yeah, Bizni.
That Hassan Ali had a stop
So,
mine.
Ram Bhavan Jadhav,
Yes.
he went out from Bizni.
With Hassan.
And story is scrap material shop at Bizni.
Business. Hassan wanted to sell it to him. So he telephoned and he took him.
Then the vehicle was found at
At Howley.
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 Howley is in Borpeta. Okay. And the vehicle was recovered on 11/12.
Yes.
The date of lodging of her is 11/12.
11/12 on
Okay.
the date of recovery.
Date of recovery is also 11/12.
11/12
Now the body.
body.
But search it.
Yes.
This Asmat was not sent for trial.
Yes.
Then 319.
319.
Okay, 319 means the evidence is already there. Let us
Yes.
see. So informant,
Informant PWR. Page 17.
is the. Okay,
Page 17.
he went out at 7 PM on 9/12.
9/12. While saying that there were scrap materials as so-and-so in the jurisdiction of Bijni, of village so-and-so, called my husband to that place with an amount of rupees 2 lakh. Husband accompanied with Hassan, went there by Indica car, carrying an amount of rupees so-and-so. As he did not come back that night, I dialed his number, but it was found switched off. He did not return on the following day too, and we searched for him a lot. I went to the house of Hassan Ali searching for him, but he was not available at home. While coming back therefrom, a phone call was made to me from Bijni police station asking me to go to the PS. I immediately went to Bijni police station by vehicle and found my husband dead there. There was blood on the face of my husband. There was mark of pressing in his neck. I came to learn at Bijni police station that when 2 boys of village Kawatika were carrying the dead body of my husband on a tela to throw it away, the public detained them and handed over to the PS. 3 boys were shown to me at the PS. I was told that among them one was named Mujid Ali and another was named Zakir Hussain. The said 2 accused persons are present in the court today. I lodged an Ejhar with PS in connection with the so-and-so incident, putting my so-and-so, the police questioned me. The incident took place on 9/12. I lodged the Ejhar on 11. A policeman of PS wrote the Ejhar. Policeman wrote the Ejhar. The policeman did not read over the Ejhar to me. I cannot say whether the cause of delay in lodging the Ejhar was mentioned in the Ejhar or not. I know Hassan Ali. He visited our house 3-4 times. The Indica car was of Sanjay Das. my husband drove the car and Hassan Ali was with him. Very important matter so far Hassan Ali's part is concerned. I did not tell the police that Hassan Ali took my husband away, saying that there were escape materials at Kawakita. I did not state in my statement to the police that I was called to Bijni police station and that I saw the dead body of my husband. I did not state in my statement made to the police that I was told that the police, the two boys of village Kawakita were carrying the dead body of my husband on a tela. The public detained them and handed over them to so and so. I did not state in my statement made to the police that 3 boys were shown to me at the PS and that I was told that one of them was named Majid and another was named Dakir. So far Majid is concerned, he was never found anywhere, madam. So at the initial stage. That Zakir and my Asmat led to the house of that Majid. Where
But
initially,
these two were found with a dead body.
my lord,
These two were found with a dead body.
that
And
is-
caught red-handed
that is
with a
what-
dead body.
What they are saying, man. Asmat and Zakir,
Huh,
not the
in a
Majid.
thela.
Tell her.
These two, Masjid and Zakir.
Asmat
Zakir.
and Zakir. 7 years in life.
And that fact is not dislodged.
That
I mean,
No,
did you, where is your
that's a 313 year will see.
Badul button? Where is your 313?
Yes. Madam, one in English and the rest is Assamese one. 2 Assamese.
What did you respond about this PW2's testimony?
Yes, your lordship, kindly.
PW2,
Examination of my lord Majid. That is page 62, your lordship, kindly. Page 62, Majid, 313.
62.
Yes.
Regarding PW2's statement,
Number Shakti.
he had deposed that you two were found with a dead body in carrying a dead body in a thela.
So we do Rahman.
3 number প্রশ্ন, no, 2 number.
2 number, yes. Huh? 14. Oh,
Similarly,
police walk over Joanna.
না জানো, simple denial only. And with the other, with PW2, PW3,
Akhi Misa, my police walk rod ulai
Okay,
diana.
the
The
inform-
rod was might have stated to have been recovered from Masjid house.
after the organizer informed Abdul Batin about the incident, Abdul Batin informed police regarding the Abdul Batin asked. And the person was just say Tilal. And anyway, thereafter I called the neighboring police, the people came there and found that Zakir. Zakir, near a river. Near a Tilal took us to a nearby abandoned house. Abdul Batin informed police. Abdul Batin is asked Asmat Ali. Asmat Ali. The third one. Asmat Ali is get about zero Zakir. Asmat. Asmut. Asmat Ali. Which two persons are with the Thela?
Zakir and Asmat. Yes, ma'am. No. Zakir and Asmat. Not Majid Maida. Majid house, when they say, right, that murder was committed there, ma'am. PW 2, 3 and 4. Right. Their status they have court attended.
Absent accused. Zakir. While we were going home, so one person, yeah. Now, who was with PW 2?
Yes, your lordship will find, P- 3 and 4. No, 3. 4 was called subsequently by telephone. Ma'am. He was called on.
What is PW 2? What is the name of PW 2?
Yes,
Shahidu.
Shahjahan made a page 25.
Returning home.
Shahidu Rahman.
No, police.
Your lordship, if he kindly, he might have.
And they replied that they were carrying this Golden Express. He used to work with a pre-
Page 24, which starts.
Naming some other material in the past. Emails. Try to see what material. See something. Zakir is also trading. Airplane chase. What is the director? What the person is Asmat. If Zakir and Asmat were pulling the thela,
Now, one is pulling, one is pushing.
whatever,
Yes.
with the thela and with the dead body, it is Zakir and Asmat.
Asmat.
And in the judgment, why the Asmat was relieved of the charge of whatever, 20 or 392 or 392, I don't know, for that 2 lakhs perhaps, and 302.
Right.
Why the Asmat was relieved of the charge of 302?
Page 100, your lordship. 100. Yep. In 100. Paragraph 71, Your Lord's Kindness.
PW, a 3/28 of page 20.
But he was pulling the handcuff. Basically, one
One
page.
minute, 1 minute.
Yes. Paragraph 113 page. Paragraph 73.
After taking the builder. When I returned, I had a teller. So he told me to be dead, but he was kept in Tani, like in the teller, on wheels. Accused Asma told me that he carried the dead body by the teller house. Accused Abdul Majid. Being asked, Asma really led to the house of Abdul Majid. Assignment surgery period. What is there in the judgment
Yes.
regarding Asmot?
Yes.
Vera?
My lord, Your Lordship, kindly say page 112 last, my lord. Page from paragraph 71, my lord, it will be page 112. Page 112. Paragraph 71. Your Lordship got it. Although the circumstantial evidence as well as the other evidence as discussed above appears in equal footing against all the accused, but the case of case number 3 Asmatari appears to be different on the following grounds. In the investigation officer recorded the statement of accused person and also collected evidence. After going through the materials, IO was convinced that A3 was not involved in the offense on the ground that he was asked to throw the dead body by accused number 1 with a handcuff on the promise of payment of so and so. Hence, the A3 was not sent up for trial in the charge sheet. Subsequently, A3 was made.
IO also does not know what is section 201.
Exactly.
Right?
Yes, madam. Yes.
So he is ignorant of 201
201.
IPC.
Then 72,
Good.
Your Lordship, 72. It appears from the evidence of PW 2 and 3 and 4 that the A3, that is Asmat, who was pulling the handcuff, did not even try to flee away from the spot. That is the main ground. Further, on inquiry by those witnesses, A3 told them that he brought the handcuff from the house of a person who is not known to him, and he led the witnesses to the house of A1. As such, from the aforesaid evidence,
Where from these are derived?
it is not from evidence, ma'am.
Not from evidence.
Not from-
161.
Yes. Oh, 161 madam,
From investigation material.
that is investigation,
Incorporated in the judgment.
judgment.
Good enough.
This is how, my lord.
Good.
This is what is going on, my lord.
Good.
I have nothing to say, my lord.
I have
That
also
part your
nothing to
lordship-
say.
Your lordship can say, my.
Interval. Very clear evidence on the material, not translated into evidence. But when clear materials are there under section 201, he is not sent up for trial. Thereafter, the trial court.
Whole case went 201, basically.
That is one. On the basis of that, if you can build up a case under 302, that is a different matter.
Right.
But the trial court went into the materials.
No, nothing.
Further on inquiry by those witnesses, where are those
Nothing.
inquiry?
That-
Nothing.
That is what I'm saying. That is not.
Yes, state. Not previous. All these are.
These are all my lord from the case diary or something, my lord.
Hmm?
From the case diary, I think he had narrated.
Yes, they are good.
Probably he might not have enough time, my lord. So,
Lordship, PW 2 and 3, they have witnessed confidence while carrying the.
Question is now, Asmat Ali is 120B only, right? Asmat and Zakir are the two persons who were found with a thela. They may not be charged. I'm leaving aside 302. It could have been a case of 201 for both. 20, there was absolutely nothing about 201. Neither charges framed. No charge was framed under 201 against Asmat. And if he does not know how 120B came, if we assume for a moment this para 72, if you read, these are on inadmissible materials, whatever, right? Rightly or wrongly something, ultimately it is 120B. 120B when two persons, two or more, makes conspiracy to do a illegal thing or to do a thing in an illegal manner. If there is no meeting of minds, para 72, he does not know. Where is the conspiracy then?
But Lordship will not solely read.
No, that's,
Para
I'm
72,
asking
my lord.
you. So 120B against Asmat, based on inadmissible material, para 72, inadmissible. Nobody, PW 2 or 3, did not say that something. This might be said by Asmat Ali in his interrogation. I did not know. I was asked 500 rupees. Had it come in evidence that 500 rupees was given? No.
Lordship,
To pull the two gunny bags, he did not know there was dead body. All
but
this story.
They knew it was break.
Huh?
They replied it was break, my lord. They didn't say, like, they concealed the truth, my lord, and say it was break, my lord. One tried to, like.
Question is this story, page 7,
Lord-
paragraph 72 story. Paragraph, no, I am saying one by one.
My lord.
Paragraph 72 story, these are not on evidence on record. Evidence on record means testimony of the witnesses and other documentary evidence, material object, whatever. These 72 findings are not on the basis of admissible evidence. The trial court used the materials in the case diary or 161 statement of the accused.
So I'm making.
That is one, Asmat Ali. Now, we are not against appeal against acquittal. We are not against any appeal from the state. Then whatever is there, paragraph 72, it is inadmissible. That is one.
The appellate states, my lord, lordship may still reappreciate the evidence.
No,
which are reports are not
reappreciate.
full. The evidence of PW.
Not for the purpose of bringing in 201 or not for the purpose of convicting him for, under section 20302. Even for inadequacy of sentence also. We cannot do unless we put him in notice. But here is the case, paragraph 72 at least against.
Maybe,
As-
Lordship, my lord.
Now let us see,
observation of
Mojid,
law.
Mojid,
Yes.
how Mojid come?
Mojid-
Asmod we can,
They say, my lord, we have brought it from Mujid house.
Asmod has been getting benefit from everywhere.
Yeah. No, my lord, they say,
Not from evidence on record.
my lord, Asmat and Zakir, as is appears, that they have brought the dead body from the house of Mujid.
How,
That's how Mojid come.
Mojid, how the Mojid came?
Then how Mujid, this is how Mujid came, my lord.
Hmm.
Both of them, one say, my lord, Zakir led to house of the king, another witness says that, my lord, Asmat led to the house of the Mujid.
So Mojid, which is the part
Yes,
relating to Mojid?
Mujid, your lordship will find page, oh, paragraph, yes. Six paragraph. Page 100, man.
100.
Paragraph 36.
Asmod is only 120B.
120B,
Huh.
but both on the same footing, man.
Huh.
Asmat and Zakir on the same footing.
So you want to say that I also be 120B?
Yes. No, I am not saying, I am saying complete, my lord. Where is the community, where is the, my lord, the finding?
Lordship, evidence of PW two,
Huh?
page 25 of the compilation. The late,
Right, no,
Yes.
whatever is there, whatever is emerging is that Asmod and Zakir were with the Thela.
yes. And they have
And Thela had the dead body.
dead body,
That is
yes.
established.
yes.
That was.
And they made extrajudicial confession before these two witnesses that they have brought the dead body from the house of Majid. That's how.
So that could be a case of 201,
My lord.
not murder.
That-
No, you have to link it.
Yes.
You have to link it with cogent evidence. Now, then they said this Majid, whoever it says, we brought it from the house of Majid. That is, I
Just
think,
paragraph 36, but only to 1 minute, one more. Page 100, paragraph 36. On the way, my lord, page paragraph 36, last 3 lines, man. On the way, they saw that one person was pulling a handcuff, while another person was pushing the same. Your lordship got it wrong. Pushing the same. Then they asked them what they were carrying on the handcuff. Thereafter, they noticed 2 gunny bags covered by a blue color tirpal on the handcuff. When they tried to look in the gunny bag, just then A2, that is Zakir, who was pushing the handcuff, fled away. But they apprehended A3, that is Asmat. In the meanwhile, A2, that is Zakir, was also apprehended. by the villagers and was brought near the handcuff. PW4 is another witness who was called by PW3 to the spot, and he saw the dead body on the handcuff, which was carried by A2 and A3. Immediately, PW2 and 3, 4, along with other villagers inquired A2 and 3 as to where from dead body was brought. Then both of them admitted that the dead body was brought from the house of A1, Mojid.
So Zakir and Asmat
Yes,
tentatively same set of
on the
evidence.
same footing, same setting. One pushing, one pulling.
Huh. It is easier for the person pushing to run away
Pushing, but
instead of the person, because it is always easy for the handyman to run away,
yes,
not the driver.
not the driver, madam.
After.
So here driver run away, madam.
No, no. Pushing, he is the handyman.
Pushing was handyman, madam. That here who was pushing was
Zakir.
Zakir.
So the court gave the benefit of doubt to Asmat.
Hmm.
He was not in the conspiracy. On the basis of material
That was
paragraph
not-
72. Paragraph 72.
Yes, plus 72. Conspiracy no here, madam. Where the conspiracy? Nothing at all. FIR say Hassan has, maybe Hassan might have.
Oh.
Everything would come out if Hassan was might have traced out.
No, that is a this is fallacy. Paragraph 72 trial code relied on materials which are not on evidence on
That's
record
what, but in the case diary.
and in the case diary. On the basis of that, this man was acquitted of the charge under 302, saying that he was not involved in the carrying of the dead body. He was given 500 to pull the gunny bags, and he was not aware.
He admitted that out because he bought it for money 500 rupees. What he said.
He pulled the car, thela.
Yeah.
Is it not?
Yeah, he said for 500 rupees, he was promised to give 500 rupees to carry the teller.
Huh,
that
and
part is
card.
admitted.
From the house of so and so.
Yeah. Both of them admitted that that.
So it is doubtful A3 is involved in the murder. If this is correct,
Right.
then
Zakir
where is
also-
120B?
Then also when Zakir also there is a doubt. My question, both of them on the same footing.
And how was it? How was it?
Mojid nothing, madam. Mojid, I couldn't find anything except saying that Mojid also they have gone there. Mojid was not, it was a farmhouse, madam. It is not a house where somebody stay, madam. That was a farmhouse. It has come in the record also, in the evidence, madam. It was a farmhouse. Mojid resides somewhere else, madam.
Shit. The compilation, I got it, when the matter was started. Can it be there? I'll just have a look at the evidences.
Madam, that.
Or tomorrow,
Now, what more she can say, madam?
to go through the judgment.
You have gone through
After judgment, the evidence is present. Once. It was not before.
all the time, my lord. This time happens. This.
Last time you saw you time.
No. I have not taken. No. My land, honorable, they have fixed, madam. Today it was fixed by your lordship.
So I took a good time. Every time.
Your lordship may, already your lordship has seen, your lordship passed any order, whatever your lordship may. Again, we have to come, my lord, here again for one case several times, my.
No, your submission is later reply tomorrow.
That is up to
Your
you.
submission is
That
complete.
is absolutely up to your lordship.
Evidence on record. No, we are also concerned with the criminal jurisprudence also, not only the appellant's case, because evidence on record have been ignored and evidence not on materials not on record
Got it.
have been taken into consideration. So
But whole
this,
case.
this kind of thing will cause prejudice to either side.
No, that matter.
To the appellant as well as the prosecution
But
also.
criminal jurisprudence also your lordship is to see, madam.
No, I have to see.
That the 99% minor goes on, yeah. Innocent person should not be convicted. This is criminal jurisprudence, madam.
No, I'm concerned about the appreciation of evidence by the learned trial court, where he has drawn inferences, making use of the statements made in which is available in the case diary. And while writing paragraph 72, he did not make use of the evidence on record.
Nothing.
Which is, and he used the statements and other materials in the case diary, which is not, he is not permitted to use. And it is not admissible in
That is why
evidence
for your
and
lordship-
cannot be read into.
That is why I appeal before lordship.
Heard Mr. Teacher, Senior Counsel Estate by Mr. Ayuch and Mr. Anuddin, Learned Counsel for the, and Mr. Asdas. And Ms. P. Other request to Ms. P. Lansing, additional, I will get you. Request to Ms. List the case tomorrow.
For further hearing.
Correct.
Obliged to you.
It does. After the order matter, we'll take up that part.
Number 25 and 26, that absence of PP, that matter, probably.
Not possible, I am
therefore,
hearing with another matter,
therefore,
not possible, we'll take into account at 2 o'clock.
For 18.
May please.
Lordship, step was not
Step
taken.
not taken.
No, today I will take the step. Kindly allow-
Mr.
B. Kakoti.
Heard Mr. B. Gowri, Learned Counsel for the appellant, and Ms. A. Begum, Learned Additional Public Prosecutor for the respondent number 1, State of Assam. Post appears the office notated. Step not taken.
Objection is fine.
You have received the objection.
I just.
IA. I. It's one submission regarding IA.
No, 1 minute. Who is Bolendas?
What is your class? Bolinda. That's no.
Nowhere it is mentioned that it is.
Bolinda's no. Vaikuntha Das was. Vaikuntha Das.
Who is the response number 2?
That's one I know. He's the informant.
Vaikuntha,
He's the informant.
Bolen,
Vaikuntha Das.
not telling.
Question.
In the records, nothing is there. That steps have been taken.
Party family member after obtaining
9. We'll go by the record because it is not telling. Here is the office note dated 14/5/2025. Epilogue likhibok. Mr. Kakoti, Learned Counsel for the Appellant, has submitted that he may be granted 3 days time to take steps for service of notice upon the respondent to in terms of the, in compliance of the notification dated so and so. Post of the play is allowed. The learned additional public prosecutor is to obtain a report from the officer in charge. Halkusi police station case number. Halkusi police station. By the next date of list. Nothing is there in the record. Vaikuntha,
Vaikuntha.
not Bolen.
Lordship Vaikuntha.
Item 19.
IA, Lordship one IA.
As the
That's it. I need to submit.
case records of the, from the trial court have been received, office to take steps for preparation of the paperwork. A report is to be submitted by the registry. As regards on the next set of listing, as regards the readiness of the paper, as regards readiness of the paper, place the case upon police.
Item 19.
May I please your lordship? My lord, I am appearing as legal aid counsel, my lord. Appeal is against this
Yes, sir.
judgment and order passed by
conservative.
learned species.
Art Miss P. Wardole, Learned Legal Aid Counsel
Yes, my,
for the applicant appellant, and Miss A. Begum, Learned Additional Public Prosecutor for the opposite party, that's respondent number 1. State of South. Post of. As per the order dated 27/5/2025, of the Loajiba Court. Service of notice upon the respondent number 2 is complete. Post of. None has appeared on behalf of the opposite party number 2, huh? Opposite party, that's respondent number 2. Stroke in command. Despite service of notice till date. Now, it's an application is under section 5 of the limitation of 1963. Is preferred seeking condonation of delay of 30 days in preparing the connected accompanying criminal appeal against a judgment dated 18/12/2024 and an order on sentence dated 21/12/2025. Huh? What?
my lord, on 5/4/25 already delayed on. my lord.
1 minute, 1 minute.
We admit you.
Judgment of conviction cannot be on 18/12/2025 and an order on sentence in 21/12/2025. 21/12/2024. Passed by the Court of Land Special Judge Poxo at Gulaghar in special Poxo case number 43 of 2018. Posted by the judgment and honorable sentence, the applicant, appellant has been convicted for the offenses under section 307 IPC and section 376 IPC as well as under section 4 POCSO Act. Those stuff in view of section 42 POCSO. Applicant has been sentenced to undergo rigorous imprisonment for 15 years to pay a fine of ₹25,000 with deposit stipulation. For the offense under section 307, the applicant appellant has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of ₹15,000 with deposit stipulation. We have gone through the statements and environments made in the application, more particularly paragraph 2 thereof. Also, having regard to the statements and environments made in the application, we have a considered view that the applicant has been able to explain the period delay of 30 days, showing sufficient cause. Condoned rested the connected events. The respond number 2 service over.
Item 20.
Wait, please, Your Lordship. Lordship, as per the last order, the applicant was produced before the Medical Health Review Board on 8/5/25. Subsequent, there's a flag B, my lord, in the file, orange color, I guess, orange or pink color.
Flag
B,
B.
Bombay. But subsequently, a report was sought from, to be placed before the MHRB after he was produced on 25/2025, as per that report.
25/5.
20th of May.
20.
That is the last update, my lord. 25/25, he was supposed to be produced before the Mental Health Program, Nagaon District, or Mental Health Review Board, Morigaon.
So,
So there should be a report of 20th May. That is not on record. If that is what.
what Mr. D.K. Bora said, council for the applicant.
That he was, mental board was set up, lordship. And we was produced before the mental board. Then there was a report from the doctor board that he may be treated regular basis on.
Where is the copy to Mr. Bora Said? We'll take it up on Monday. Huh?
That is after lordship's order. Then lordship.
And A. Begum, United Edition, County Prosecutor, Assam for the opposite party, that's responding state. MS Begum has placed a copy of the innocuous letter number so dated 2/6/2025. Addressed to her by the Superintendent District Jail Morigaon, annexing therewith a report medical report as regards the applicant, also, MS Begum, is to supply a copy of the office letter dated 2/6/2025 along with the medical report to Mr. Bhattacharya for his information. Also, raise the case on Monday, 16. The copy of the office letter dated 2nd June 2025, placed by Ms. Begum, a copy each. Placed by Begum is to be kept with the case records. With a file of
Obliged.
marking it as document X.
Items 21 and 22.
May I please, Lordship? Lordship, it is our second application for suspension of sentence during.
Notice has to
pregnancy.
go then.
Yes, Lordship.
Notice has to go
Yes, Lordship.
because state should have the opportunity to file an objection.
Yes.
Heard, Mr.
M. Pathak.
M. Phatak, learned counsel for the applicants, appellants. And Ms. A. Begum, learned addition, public prosecutor for the opposite party, have this respondents from a state of Assam. So submission application under section 430. Within bracket 430, BNSS 2023. Seeking
Lordship.
suspension of execution of the sentence passed against the applicants, appellants, and for their release on bail. So issue notice retirement in 4 weeks. As MS Begum has appeared in accident notice on behalf of the opposite party, just respondent state, issuance of formal notice is dispensed with. The learned additional public prosecutor is to file, self-file. It's the state's objection, if any, on or before, invariably on or before the next date of the listing.
Lordship, I have a small submission. Lordship, already co-accused has been released on bail by Honorable Apex Court. I have enacted the Apex Court order, Lordship. Co-accused in the same judgment. I have enacted page 11, Lordship. No, Lordship. No, Lordship. Earlier rejection, they filed appeal against the earlier rejection order of the co-accused.
No, Mr. Counsel,
Yes, Lordship.
did these applicants had filed any other application earlier?
Yes, Lordship.
Yes,
Lordship. I am.
You
appearing-
filed earlier an
Yes,
application
yes.
seeking
It was rejected.
suspension of sentence.
Yes, Lordship.
So did you
Lordship.
annex a copy of the order?
No, Lordship, but I have the copy, Lordship.
You should have done so. And anyway, for examining
Yes, Lordship.
the matter of suspension of sentence,
Yes.
whether it is on the ground of parity or different sets of evidence, we have to examine. And plus, statute requires an opportunity for the public prosecutor to file an objection. Just because Honorable Supreme Court has allowed an application for the co-accused, the procedural compliance is to be made. What? Huh? Usually produced before the Look, এটা বিপিন কুমার আর এটা কি সুরজ কুমার সেইটো গাঁঠি দিছে।
16.
No, this is for the special court to decide. Read the order. Supreme Court's order. Appellant shall be produced before the special court within a maximum period of 1 week. Okay. Mr. S. Mitra, learned counsel for the appellant in 22, is in attendance.
Item 23.
May I please, your lordship? May I please, your lordship?
Newly filed, earlier filed,
No, lordship,
fresh,
please.
Hmm?
No,
first
lordship.
one, first application.
First application.
Heard, Mr. Yarshub. Learned counsel for the applicant appellant. And Mr. R. Kosik, learned. Additional public prosecutor for the opposite party, that's respondent number 1, State of Assam. The instant application under section 430 BNSS 2023 is preferred seeking suspension of execution of the sentence and passed against the applicant appellant and for his release on bail. Full stop. Issue notice returnable in 4 weeks as Mr. Kosik, learned additional public prosecutor, has appeared and accepted notice. On behalf of the opposite party, that's respondent number 1, issuance of formal notice is the same as opposite party, respondent is dispensed with. Let us see.
So we have this receiving.
Steps. Service complete. Okay. Do you have any acknowledgement?
Yes.
It is not available here. But again, that was in appeal now here. Yes, in the appeal. Now there is a fresh application now. What to do? None has appeared. At least she must be put on notice.
Lordship. Lordship.
Then amicus.
Yes, yes.
The applicant appellant shall take steps for service of notice upon the opposite party that's respondent number 2 by in terms of a practice direction. The learned additional public prosecutor is to obtain a report as regards service of notice upon the opposite party that's respondent number 2 from the officer in charge. Geleki police station case, police station. By on or before the next day listing. I said. Heard Mr. A.R. Som, learned counsel for the appellant, and Mr. R. Kosik, learned additional public prosecutor for the number 1 from a state of Assam. Full stop. Mr. Kosik, learned additional public prosecutor, has submitted that the service of notice upon the respondent number 2 is complete as he has received a report as regards service of notice from the officer in charge, Galaki Police Station. So, the case records from the trial court have been received. Full stop. The office to take steps for preparation of the paperwork, release the case after 4 weeks for a report as regards readiness of the field.
Acknowledge, your lordship.
Supplementary list for hearing. Item 28.
Yes, Mr. Amir, somebody. Yes, what was your peer?
Item number 25, that matter relates to that.
Public prosecutor.
Yes.
But
Today I am paying for a date if it is not taken up today. And
we'll find out
if I
from
is
the
also pending.
diary. From the diary, we'll find out. এইটো মনত ৰাখিবচোন, ক'ৰবাত আছে যদি হা চাই পেলাই যদি
Problem.
same thing.
No, different appeal, madam. Appeal against POCSO, madam.
What offense?
POCSO, madam, section 6. More than
That
two
is,
years.
Amit's case may be a special one, but otherwise we are taking up more, where the sentence is more. Say, period of incarceration is more.
Madam. Here it's only 2 years.
At least, I use that discussion. It is 2 years,
2 years.
maybe some after vacation,
Madam, I'm adjourned
maybe
for a
after
day.
vacation.
Yes, adjourned for a day.
Ajahn for the day. Okay. Mr. S. Das, applicant. Bibhui. লিখি দিব, and Miss
T Devi on behalf of As Business Legal Aid Council.
are present. Short for the land council board of parties, the case appeal is passed over for the thing.
Madam. Highly honorable.
Item 28.
Twenty-five, 26 could go. Implication. More judgment. That he deposed falsely that the appellants showed the place of occurrence. Full stop. He further stated that police personnel did not take them to the place where the dead body was thrown. Close para. PW 18 did not know the informant. And accused persons other than A2. He did not also know the deceased. PW 18 stated that in the year 2008, he was working as a journalist. As regards the incident, he stated that he, along with few other persons, went to the police station to collect information regarding the murder of the deceased. And when they reached the police station, they saw the police personnel interrogating one person named, quote unquote, Paul stroke Mall, M-A-A-L, page 43, regarding the incident. He stated to have heard that the said person confessed. He stated to have heard the said person confessing his guilt before police, but he could not identify the person in the court. Nineteen to who is there, no? Doctor who is in special. These two nasil. Equals to already. Equals to no? Equals to Subor, okay. PW 20 was an uncle, was a maternal uncle of the informant and was a younger brother of the deceased. Though he knew A2, he did not recall anything about the other accused persons. As regards the incident, PW 20 testified that the deceased was a regular worker at the house of the accused, A1 prior to her death. Prior to the incident, he asked his nephew, 9-dash informant. Whereabouts of his mother? Full stop. In reply, PW 9-dash informant told him that his mother went along with the accused, A1 to Guwahati. But did not tell him about the region for going to Guwahati. PW 20 further stated that elder brother of the accused, A1 told him that A1 was not at home for 3-4 days. So then he, along with PW9 as informant, searched for his elder sister everywhere, but they could not find her. Full stop. PW20 further deposed that he heard from one sweeper boy that he brought one dead body from the Ideo Pukuri tea estate to the police station as per the instruction of the police. Full stop. Then, he suspected that the recovered dead body might be of his elder sister. Full stop. He immediately went to the police station, but could not find the dead body in the police station. Full stop. The police personnel asked him whether there was any mark like tattoo in the hand of Junaki Wala, and he replied positively. Full stop. From that point of time, he suspected the accused, A1, to be behind the killing of his elder sister. Full stop. When cross-examined, PW20 stated that though he used to see A2 daily in the Sonari town, but he did not know how A2 was linked with the case. He stated that he did not see the two appellants at the time of the incident in the police station. He also did not see the dead body of his elder sister either in the police station or thereafter. He was also not aware who had done the cremation. He further stated that he and PW9 as informant did not report to police regarding missing of the deceased as they were searching for her. He also denied a suggestion that the disease was not a regular. Disease was a regular worker in the house of the accused A1. Suggestions. And he did not state before police that the disease was a regular worker at the house of the accused A1. Ah. Page 147. That judicial officer. Reporters. Journalist, reporter.
PW6, my lord, is the reporter, my lord. PW8. Then
From the testimony of the prosecution witnesses,
PW12. 13.
comma,
And 18.
PW7. PW6. পিছত share কৰি দিব। No, police station যোৱাকেইটা। Police station যোৱাকেইটা। Oh, PW6. PW7. Police station যোৱাকেইটা। PW7. PW8 also. No, PW8 is that man. Ankit, double witness.
PW12.
Ah.
Topic. 13.
News train. PW
12.
12. PW 12. PW 13. PW 18. Go in the testimony from the testimony. And PW 18. It has emerged that at the relevant point of time, they were serving as journalists stroke reporter in or newspaper stroke television channels, etc. Post op. All of them have testified to the effect that after hearing the news about recovery of a dead body of a woman, right? They went to the police station. Post op. Going to the police station, they found that they had found and heard they have found that police personnel were interrogating the persons who were suspected to have committed the murder of Junaki Goela. And according to their testimony, they heard at the police station they heard of confessing the guilt before the police personnel. at the police station. Full stop. কি বললো নম্বর কেটা? 8, 13, 18, 15 was 15 no 15 vehicle wrong. 18, 18. It is settled that formal arrest of the accused is not sine qua non to bring into operation the rules of evidence embodied in section 25, section 26 and section 27 of the Evidence Act. Full stop. As per section 25 of the Evidence Act, a confession made to a police officer shall not be proved as against a person accused of any offense. Full stop. Section 26 of the Evidence Act has provided that no confession made by any person while he is in the custody of a police officer, unless it be made in the immediate presence of a magistrate, shall be proved as against such person. Full stop. Section 27 of the Evidence Act is an exception to section 25 and section 26 of the Evidence Act. It makes that part of the statement which distinctly leads to discovery of a fact in consequence of information received from a person, quote, accused of an offense, unquote, in the custody of a police officer, to the extent it distinctly relates to the fact thereby discovered, admissible in evidence against the accused. The fact which is discovered as a consequence of the information given is admissible in evidence. The fact discovered should lead to recovery of a physical object, and only that information which distinctly relates to the discovery can be proved. Para, the expression custody, quote unquote, like the bar under section 25 of the Evidence Act applies equally whether or not the person against whom evidence is sought to be laid in a criminal trial was in custody at the time of making the confession. For the ban to be effective, the person need not have been accused of an offense when he made the confession. The reason is that the expression, quote unquote, accused person, the expression, a person accused of an offense in section 20, I can para 53. explain who is it. Then as soon as an accused or suspected person comes into the hands of a police officer, he is no longer at liberty, he is under check and is therefore in custody within the meaning of section 25 to 27. The two appellants according to it has emerged that the two appellants it has emerged from the testimony of the IO PW 21 that the two appellants were apprehended. April 6, maybe. Were apprehended on 6/9/2008. And thereafter, were taken to the police station for custody. Even it is accepted the testimony of the aforementioned 5 or 6 years prosecution witnesses regarding making of confession by the two appellants before the police station, before the police person in the police station to be true, then such confession is not admissible in evidence because of the prohibition contained in section 25 and 26 of the Evidence Act. Who is the man who found the rope when the police personnel discovered a dead body? Witness that man, some Bora or
There were one person, my PW3 was there, my lord.
no,
But
PW3 we have already discussed.
Yes.
That the
Mintu
PDB
Google.
secretary, right?
Mintu Google,
Mintu, yes, Mintu.
phase 2, it was
Mintu is PW
10 man.
10.
Phase 2 is 28.
The prosecution witness, PW 10 testified to the fact that when he witnessed he was witness at the time when the dead body of the deceased was found lying in a drain near Aidopukuri Tea Estate. Full stop. From the evidence on record, comma. He had further testified that on that day itself, comma, the police personnel found a plastic rope and a pair of sandals beside the dead body, comma, which was found in a drain. Full stop. If he was also, okay. He further testified that he did not know where from the police personnel had brought the rope. Full stop. Thus from the testimony of PW 10, comma, the dead body of the deceased and the plastic rope were found at the same time at the same place, comma, which was prior to the institution of the affair. Institution and registration of the affair. On which date? Four nine 2008. Full stop. On the other hand, the seizure list, comma, EXTP2, whereby one plastic rope was seized, comma, was prepared on 6/9/2008. Full stop. As per the said seizure list EXTP2, comma, the plastic rope was recovered on being laid and shown by the accused, comma, A1. Which was kept concealed at section 6, comma, Idopukuri Tea Estate. Post. The seizure list EXTP2 bore a signature of P10. Post. Thus the recovery, the very recovery of the plastic room the factum of recovery of the plastic rope has become clouded. When recovery is made prior to any alleged disclosure statement, comma, the provisions of section 27 of the Evidence Act is not applicable. rope is gone. The evidence was of when we analyzed the testimony of the with prosecution witnesses, comma, PW1, PW2, PW3, PW4, PW and PW5. We find that their testimony is in the nature of hearsay. All are heard, all have heard. And they did not know anything about the actual incident. Full stop. Ankit Kurmi, comma, who was brought by the prosecution twice to depose evidence, and who deposed as PW12 and as well as Ankit Kurmi, as well as PW11, had testified that he did not know anything about the incident. Full stop. The prosecution witness, comma, PW14 was declared hostile by the prosecution. And even after cross-examination by the, even after his cross-examination by the prosecution with the leave of the court, comma, the prosecution would not elicit anything in respect of the present from him, in respect of the present two appellants. Full stop. The informant, comma, that's PW9, comma, who was the son of the deceased, had not deposed anything against the present two appellants. Full stop. It can be gathered from the testimony of PW9 that it can at best be gathered from the testimony of PW9 that it was the accused, comma, A1 who was allegedly seen last with the deceased full stop. আৰু কলো নেকি? ৰিপৰ্টাৰ আছে নেকি? অ, 12টো ৰিপৰ্টাৰ আছে। ৰিপৰ্টাৰ ইউ। হা? 11টো 11 নহয়, 11 কোৱা নাই, 12। 11টোতো অংকিত কুৰ্মী। এই ৰিপৰ্টৰ তাতে 12টো লিখি ৰাখিব দেই। তেৰটো ৰিপৰ্টাৰ 14 hostile. During the course of investigation, the IO PW 21 seized 2 vehicles, one Tata Ace vehicle and the other. Who is that? No, who is the okay? One vehicle. From the prosecution witness, PW 15. By a seizure list, EXT P3. Full stop. PW 15 was not aware about the person who hired the said vehicle during the relevant time and was also not aware who was driving the vehicle during the relevant time. Also. But the vehicle was seized from his house itself by police, and the said fact is corroborated by his wife, PW 16. Full stop. Thus, the testimony of PW 15 and PW 16 have nothing to connect the alleged homicidal death of Junaki Gola with the present 2 appellants. 7 gold. Hmm? 18 gold. So, Mama, you have a journalist again. Or journalist, 18 journalist. Journalist. 18 question on me, question 2. 9 into who is already. Hmm? Phase 2, please. Part of original. CW হৈ গৈছে CW to date to তাৰ লগতে কৰিছো there is no iota of evidence on record that the present, the two appellants herein were seen with the accused, A1 at any time. Full stop. There was no iota of evidence. There is also no iota of evidence that the two appellants herein were seen together with the deceased at any point of time. Full stop. There is also no iota of evidence that the two appellants herein, the accused, A1 and stroke or the deceased were seen together at any point of time. Full stop. Therefore, there cannot be any applicable, and there cannot be an occasion for the prosecution to bring in the last seen theory. In connection with the two appellants hearing. Full stop. Last seen. Para. Out of the 17 circumstances which the learned trial court appeared to have believed to have been established the circumstances from number Roman 9 to Roman 17 is 20 meters. Right? These are with these appellants are have been made relatable to the two appellants hearing. Full stop. When we, on an analysis of the evidence on record, including the testimony of the prosecution witnesses, we find that none of those circumstances from number Roman 9 to number Roman 17 could be established by the prosecution by cogent, reliable, and admissible evidence. Insofar as against the two appellants herein, two appellants are concerned. We are not commenting on A1. Non-appealing. Otherwise, there is a theory also, non-appealing appellant. I don't know whether it is available to the Supreme Court or to the High Court also. Supreme Court under Article 136, they do so. Pera. In a case based on circumstantial evidence, it is settled that in a case based on circumstantial evidence, comma, suspicion, comma, however grave it may be, comma, cannot take the place of proof. And there is a large difference between something that quote unquote may be proved and something that quote unquote will be proved. Full stop. In a criminal trial, comma, suspicion, no matter how strong, comma, cannot and must not be permitted to take place of proof. For a reason that the mental distance between quote unquote maybe and must be quote unquote is quite large and divides vague conjectures from sure conclusions. In a criminal case, comma, the court has a duty to ensure that mere conjectures or suspicion do not take the place of legal proof. Full stop. The large distance between quote unquote may be true and quote unquote must be true, comma, must be covered by way of clear, comma, cogent and unimpeachable evidence produced by the prosecution, comma, before an accused is condemned as a convict. And the said basic rule and golden rule, said basic and golden rule is must be applied. Full stop. Another golden principles of criminal or administration of justice in criminal cases is that if two views are possible on the evidence adduced in the case, one pointing to the guilt of the accused and the other to his innocence, comma, the view which is favorable to the accused should be adopted. Full stop. On evaluation of the evidence on record laid by the prosecution in this case, comma, we find that none of the circumstances to complete a chain of circumstances leading to to an irresistible conclusion that the two appellants herein were behind the homicidal, behind the death of the disease has been established by clear, cogent, reliable and unimpeachable evidence. Full stop. The prosecution has not been or has also not been able to establish that the date of the disease was a homicidal one. Homicidal, it is not because the reason perhaps may be due to the decomposed nature of the dead body, recovered much after the actual date. In the light of the above discussion and for the reasons recorded, comma, we are of the unhesitant view that the prosecution has failed to bring home the charge of murder. 34. 34 was there. Murder under section 302 IPC. What are the charges?
201.
201 also.
Yes.
Okay, 201 or. What are 201? In aid of section 34 IPC. Full stop. এটু ঠিক আগত। Okay, tapi aku 20 orang lagi. Ready আছে investigation. Consequently, we find ourselves not in agreement with the finding of guilt arrived by the learned trial court on the evidence stroke materials on record, discussed herein above. Post of having held that the prosecution has failed to prove its case against the two appellants herein beyond all reasonable doubts by way of clear, reliable, credible, and unimpeachable evidence, we find that the judgment and order of conviction is dated so and so, or the conviction and sentence passed by the learned trial court is unsustainable in law, and the same is liable to be set aside. It is accordingly set aside to stop. Consequently, the instant criminal appeal stands allowed to stop. The two appellants herein are to be released from custody forthwith if their custody is not required in connection with any other case or purpose. The records of the trial court are to be sent back forthwith. Full stop. 357 on para 357 regarding compensation to PW9. Anyway, that has occurred. Yes. In view of the judgment and order passed today in the accompanying criminal appeal number so and so, the instant interlocutory application stands accordingly disposed of. But don't expect today. I understand.
This client is lucky enough.
He was pressing I. He was pressing I. We thought that better to same exercise. Yes.